Okay.
Good morning, everyone. It's a minute or two after 10. We'll go ahead and get started with the Gas and Oil Board meeting for today, January 21, 2025. And we'd first like to ask you if you do have cell phones or other electronic devices that make sound, if you will mute those. Okay, we have a couple of things to do. We do have a remote attendance form that we need to approve for board members who aren't here. We need to, I guess, at least sign in with the folks who are here. So, if we can introduce ourselves, we'll start with Mr. Collins.
Willie Johnson, Jimmy Energy. Gibson board member.
And I'm Bill Harris, a public member.
Patrick Owen, public member.
Thank you. We do need to approve some, or at least vote on some resolutions for remote attendance for some board members. We have three. We have Bruce Chrysler. This morning, Bruce. Chrysler. I'm sorry. Oh, he's here. Okay, thank you. Okay, I was thinking there's a form I needed to read, but it's for residents located more than 60 miles from the meeting location. So if board members approve his attendance remotely, you say yes?
Yes.
Yes, opposed? No? We also have Donnie Ratliff. Donnie is normally the chair of the meeting now, but he's in Richmond, I believe, at the moment. So I was asked to chair, but Donnie is again more than 60 miles from the meeting location. So if we have an approval for his, I guess we need a motion for his approval for remote attendance. I'll entertain that.
Make a motion.
Second, fine, thank you. All in favor?
I can.
Yes, okay. So that's approved. And for Gus Jansen, it's Gus on. Oh, there it is. Okay, hey. And Gus, it wasn't checked, but is this a medical?
That's correct.
Usually, sorry, I have to do that publicly, but usually we have that check goes form and for us. So do I hear a motion to admit Mr. Jansen as a member remotely for the meeting? So thank you.
Second.
Thank you. All in favor, say yes. Yes, opposed. I think we're good. Do I need to, I didn't do that. Do I need to go back and have a motion made? I just asked for approval. I don't know.
Formality would be to do it.
Yeah, okay, let me do that for Bruce, so we'll make it consistent. Do I have a motion? All right, thank you. Second. Thank you. All in favor?
Yes.
Yes. Opposed? I think we're good for those. And the board has some items that we need to discuss with our attorneys.
That he needs to do.
And so
Roll call
the
for
board, sorry. Is there something?
Mr. Chairman, I think we need to do a roll call for everybody to make sure they are verified that they're on
Oh,
that they're on the call. Sorry.
If you will do that. then,
Mr. Cochran, Mr. Prather,
Yes, I'm on there.
Mr. Ratliff, and Mr. Jansen.
Yes, I'm present.
I don't think we have Mr. Ratliff with us. That's okay.
Jenny Gas and Old Boy hereby resolved to discuss following subject matter in closed session, so we do need a closed session. This meeting will be a consultation on a memo circulated to the board by the Attorney General's office. And this subject matter is exempted from open meeting requirements under the following provision of the Virginia Freedom of Information Act. Consultation with legal counsel employed or retained by a public body regarding specific legal matters requiring the provision of legal service by such counsel, and this is pursuant to Virginia Code Section 2.2-3711A K. And so I will entertain a motion to go into, I think we're gonna, how do you want to stay here or you want to go into close? We were talking about.
Stay here, and then we'll ask the Key Rock gentleman to, we'll find a place for them. Where could we?
In the meantime, let me entertain a motion to go into closed session. Okay, folks, I think we're back on. Can everyone online hear? Okay.
Yes.
Yes.
Okay. Thank you.
Yes.
We need to do an exit poll. And we would ask Sarah to bring ask Sarah to poll the board members about our whole session.
Okay, I'm just going to read a statement and then I need everybody to either agree or disagree. To the best of your knowledge, did the board restrict its hearing, discussion, and consideration in closed session to only public business matters lawfully exempted from open meeting requirements under the Virginia Freedom of Information Act, and only such public business matters as were identified in the motion by which the closed meeting was convened? Mr. Owens?
Yes.
Mr. Harris?
Yes.
Mrs. Gibson?
Yes.
Mr. Cochran?
Yes.
Mr. Prather?
Yes.
And Mr. Jansen?
Yes.
And Mr. Ratliff?
Yes.
Thank you. And we're back in open session. And so we will move on to the agenda. The board will still receive public comments. I presume there are none. You can see the list.
None.
Okay, we'll move on then. The First Bank and Trust Company escrow agent for the Virginia Gas and Oil Board will appear to address the board on the quarterly / end of the year report.
Good morning, everyone. Can you hear me okay?
Yes.
So this is our fourth quarter, end of the year for 2024. I'm assuming that everyone has received the PDF version of the packet. And we'll start with page 3, our summary. At the beginning of the quarter, we started out with $5,006,667.59. During the quarter, we received $45,289.67. We earned interest from the money market account and the Cedars account, the brokered CDs, of $18,951.52. We had fees paid from the account of $4,980.75. Distributions for the quarter was $71,897.84, leaving us a balance at the end of the year with just shy of $5 million, $4,994,039.19. You'll see on the year-to-date column that we processed $390,560.11 in distributions for the year. During the year, we processed 7 treasury dockets that totaled $65,104.66, 45 normal dockets for $325,455.45. We issued over 350 checks They ranged from 6 cents to $72,148.53. Of those 350 checks issued, 259 of those were less than $100. On page 5, this is a list of all of our outstanding checks as of the end of the year. And it is several pages long, not a lot of dollar amount, but several pages. Page 15 is the total. We have $10,560.51 outstanding. Page 16 starts our check achievement for 2025. And the total for what will be achieved in 25 on page 19 is $3,903.76. With that, we are in the process of achieving the no W-9 lists that are over a year old. I wanted to ask the board, does that need to be in place as well for the outstanding checks? Anything that's over a year old, do we need to go ahead and escheat that to the state?
Is that what we've been doing in the past?
We have not been doing the 1 year. So at the last meeting, it was discussed on the no W-9 list to escheat it if it's been on there for a year.
So if that was approved, I guess we need to go forward with that. I mean, I'm not sure what options we have if the board did vote to, I think I was here, but it's slept since then. But we did approve exceeding those checks if they've been, so we need to include that then. I mean, we need to make that change.
Okay, so we'll
Answer your
start.
question again, you were asking, should we list those as escheated or to be escheated? Is that what?
Well, the ones that are to be escheated on my to be escheated list are 5 years old now.
Okay,
We have a lot of outstanding checks that are over a year old. With the
So your
change in
question
the no
is-
W-9 list, do we
Yes.
need to take that and escheat the ones that are a year old on the outstanding checks as well?
we voted to do that. I'm hearing, so I guess we need to do that.
Yes, that's was
Okay.
advised. They have it once it's a year old, we can go ahead and.
Yeah, okay, yeah.
Okay, I will
So
start
we need-
escheating those that are a year old. So our check achievement list may be a little bigger than the $3,903.
Yes.
So anything that's over a year old, I'll start escheating, as well as the no W-9 list that's a year old.
Okay, yes, thank you,
Thank you. On page 20, this is a list of all of our accounts that are funded. Each account, the unit name, the docket number, the unit operator, the beginning balance for each account, deposits, any interest that's earned that month, Cedars interest, fees deducted from each account, distributions paid, any transfers to the no W-9 list, audit costs and corrections, which we have none, and then the ending balance for each account, as well as a status column for each account. So that starts on page 20. And it goes through page 28 for each individual account. And then you'll see on page 29, this starts our no W-9 list. So at the end of the year, we are starting to escheat the no W-9 list that is over a year old. So that includes the majority of this list, with the exception of 3 names that are on the list that were entered onto the list in 2024. So the next meeting, this list will be, as long as nothing else comes on it, it'll be about $130 versus the total on page 41 of $42,000. So the majority of this will be escheated to the state. On page 42, On page 42, the annual distributions, this is a list of all of the income we've received, all of the distributions that we've paid out since First Bank and Trust became the escrow agent in 2010. So since 2010, we have distributed out $36 million. Page 43 is the investment of the funds as of December the 31st. We had right at $3 million in the money market account, $2,994,000, and then $2 million worth of CDs. And those CDs will mature starting in August of 2025. So we did 1-year CDs up to the FDIC insurance limits at those banks. Page 44 is a comparison of the rates from the last meeting to what they are today. You'll see that the rates have changed a little bit, not significantly. Treasury rates have gone down a little bit and CD rates have gone down a little bit since the last meeting. And the last page is the CD rate ranges. So CDs ranging 4.15 to 4.25 for 3 months. And then up to 2 years, we can get CDs for 4% up to 4.15%. Does anybody have any questions or comments for me?
Questions, anyone?
I wanted to mention that prior to this, I don't think you all actually voted on eschewing the uncashed checklist or the outstanding checklist as she has referenced on
Yes.
her report. You all, I think, only voted to eschew the no W-9 list. So it might be a good idea for you to vote yes on.
We need a motion to eschew what's the best language to use? The
Outstanding checklist, also known as the uncashed checklist.
eschewing people who are on the uncashed checklist for more than a year. That satisfactory? Okay, so we'll make that motion.
Also move.
Okay, thank you. We do need a second. Thank you. Would you poll the board?
Yes, sir. Mr. Cochran,
Yes.
Mrs. Gibson.
Yeah.
Mr. Harris,
Yeah.
Mr. Owens,
Yes.
Mr. Prather,
Yes.
Mr. Jansen,
Yes.
and Mr. Ratliff.
Yes.
Anything else? And again, we do thank you for, your reporting and answering questions and whatever, as far as the bank is concerned. Anything else? Okay, I guess we're done. Thank you very much.
Thank you all. Have a good day.
Thank you, you too. We'll move on to item number 4, a petition from T-Rock Energy LLC for modification of pooling order M-26-1. The docket number is BGOB 4-0220-4280, paragraph 9.2. The unit is T-Rock M-26-1, and I have a separate docket number. I'll read that, but that docket number is BGOB 24-0220-4280-01. I guess that's the modification for this petition. We'd ask all people who want to speak to this petition, please.
Freddie Mullins on behalf of the T-Rock Energy.
Wait.
Also have Morgan Page with me.
Mr. Pate, do you swear and affirm that your testimony is the truth, the whole truth, and nothing but the truth?
May again.
Parents, if I may, I'd like to open with a brief statement. We're here today seeking an amendment to the pooling order governing well M-26-1 in Dickinson County. This amendment is critical to aligning financial obligations and operational framework of the unit with the realities of coal-bed methane production, sealed job areas. The proposed amendment, in section 9.2 deals with shut-in payments. The proposed amendment would switch from paying $1,000 per lessor to $1,000, being paid pro rata to the owners in the unit. Proposed amendment ensures proportional and equitable compensation through a pro rata distribution model while capping shut-in payments, which helps ensure the economic viability of the unit. We believe this amendment aligns with the board's mandate to ensure efficient and equitable development of Virginia's natural resources while upholding the rights and interests of all the shareholders involved. And we thank you for the opportunity to present our case this morning, and we will call Mr. Payne. Mr. Payne, can you state your name, please?
Morgan Payne,
And how are you employed, Mr. Payne?
geologist at Key Rock Energy.
And is Key Rock Energy LLC authorized to conduct business in Virginia?
Yes, sir. We have a bond on file.
All right. And can you provide an overview of Key Rock Energy's operations as they relate to coal bed methane production from sealed gob areas?
We drill wells into the sealed gob areas of either abandoned or active mines for the purpose of methane generation. The methane is then metered and flared, and that generates carbon credits through the California Air Resource Board, and those credits have been sold on the open market.
Speaking specifically about the application we have in front of the board, can you give the total acreage of the M26-1 units?
Approximately 816 acres.
And how much of that does Key Rock have leases for?
79.77%.
And these other, a little over 20%, has notice been provided to those owners?
Yes, sir.
And how was notice provided?
Certified mail return receipt requested to all known unleased owners, and the unknown owners were notified by publication in the Dickinson Sun.
All right, and I think you said approximately how much of the unit is unleased?
20.23%.
And how much of that, approximately 20% is unknown?
0.37%.
And can you explain the process for extracting and utilizing the coal bed methane from the sealed off area?
We target the lower Banner coal seam at deep mine 26. The sealed areas are depressurized when we drill into them. The methane comes to the surface where it is metered and flared.
And which coal seam are you dealing with at this particular well?
The lower Banner,
And what is the depth of this well?
approximately 375 feet.
And what is Key Rock predicting as the estimated recoverable reserves?
340 MMCF.
And have you participated in preparing the AFE for this well?
Yes, sir.
And what was that come?
$156,460.
Now, we've already been to the board one time on well M26-1. Can you explain the reasoning behind the proposed amendment to change paragraph 9.2 government shut in from per lessor to a pro rata distribution according to ownership?
First, Key Rock receives income from all of our projects on an annual basis instead of a monthly basis, which is typical for coal bed methane wells. But second, our financial model that we use to determine drilling and production and operations are based on a unified mine-wide lease structure. The lease structure ensures that shut-in payments are distributed pro rata based on an ownership percentage, preventing overcompensation of smaller interest owners.
And how would this amendment ensure fairness to all of the owners?
The unified mine-wide lease structure aligns with Key Rock's business model, which depends on annual carbon credit revenue. The model requires consistency across all pools within the mine. But bluntly, Key Rock did not survive when we look at the current shut-in royalty clause in the pool.
And what steps would Key Rock take to ensure compliance if an amended shut-in payment structure was approved?
Key Rock will implement clear pro rata calculations capping the total monthly shut-in payment at $1,000 for the entire pool. Transparency minimizes disputes and ensures equitable compensation.
Now, if the board saw fit to, allow for this amendment, how would it protect the correlated rights of all stakeholders and promote equitable treatment?
The amendment ensures equitable compensation by distributing payments based on ownership percentages, which aligns with the correlated rights doctrine. This prevents any party from disproportionately benefiting or being disadvantaged.
And, and you said you had testified that unless this amendment is made, Key Rock, could not sustain its efforts on its current well. Is that correct?
Correct, as it is written now, if the well was shut in for 1 month, Key Rock would owe $1,000 per mineral interest owner, of which I think there are 20 to 25 in this Silcock area.
But they only represent approximately 20% of the ownership.
Correct.
Okay. And, in your opinion, if the board were to grant our application today, would it prevent waste, promote conservation, and protect the correlated rights?
Yes.
That would be our, evidence, Mr. Chair.
Questions from the board?
I have one question. I know you gave us the purpose of the change, but if I am a mineral owner, what would be the difference in the amount of money I would get from the first program you have set up and what I would get with what you're proposing?
Well, in the first setup, under the current existing pool order, every mineral owner, regardless of their percentage ownership, would receive $1,000 a month. If the board approves this, depending on your interest, it would be a portion of that 1,000. Given that Intervest owns nearly 80%, your payment would probably be somewhere, I would assume, less than 50.
So it would go from $1,000 a month to 50
In my
under
opinion,
this.
depends on the percentage ownership. But yes, it would effectively match the royalty layout, where Intervest would receive 80% of the total royalty on this, and all the lesser mineral owners, whatever their percentage is. But I would guess that every person in this pool would go from $1,000 a month to somewhere less than $1,000.
Could you tell me why that wasn't considered when you did the first proposal or whatever?
Well, the two leases we have with Intervest were both taken prior to us being required to come in front of the board and fully, initially the director back in 2020 approved this project without a permit or without coming in front of the board. And so the leases that we took with Intervest are a mine-wide lease. So meaning the shut-in royalty on the Intervest lease only kicks in if every well we have inside the mine is shut in. When we first came in front of the board, we were advised to use the Intervest lease as part of the pooling order. But at that time, the Seals Gob area, the D mine 41, were represented under 100% Intervest lease. So the language for those didn't matter. I would view it as oversight that it continued into D mine 26 for your mineral ownership. You go from having to Intervest with one owner to 20 to 50 owners.
When you first did the first proposal, you did have the option to do that. You did have the option to make your own instead of going with this or whatever.
You mean make the lease?
Like the, yes, the first.
Intervest is the entity who created the lease for both D mine 26 and D mine 41.
And you assumed that in law. You assumed the whole project, you assumed the lease.
Yes, we agreed with all of their lease terms.
But you did have an option to change those lease terms.
I think we had an option to change the pooling order language. I don't know that we had the option to change the lease term. We could have proposed it, but I don't know if Intervest would have accepted the proposal.
So the $1,000 per month was in their lease originally with their,
Yes, sir.
but they sort of had 100% control of everything, so.
At the time of the signing of the lease, we were under the assumption that we did not need the permit for wells for oil and gas. And that they did not need to come in front of the board. So our operational model was, we took the roughly 80 to 90% mine-wide Intervest leasehold. And when you apply the shut-in royalty in that scenario, the 1,000 a month to Intervest would only kick in if every well inside of their lease was shut in. So now that it's been applied on a pool basis, what you end up with is if this well in this pool is shut in, under the current pooling orders, we would owe effectively everyone but Intervest a shut-in royalty, despite the fact that they're the dominant mineral, 80%.
And I know this is, well, other leases you have for degassing or similar things to remove the methane, do they have this provision in them? I mean, is this standard?
The lease with Intervest is by and large a coal bed methane lease that's getting rewritten for carbon credit application. Some of our leases, especially in West Virginia, do have shut-in royalty, shut-in payments to the mine owner and operators. Some of our leases in Illinois don't. It varies state by state. This Virginia, though, as far as PROC is concerned, is the only state that requires pooling unleased structures. So by and large, our shut-in payment across the board are usually just with the entity that's leasing to us. We don't have this situation in any other states or any other operation.
On the M26 ones, your other leases, any of the other leases have shut-in label?
No one yet has taken an offered lease from us. We mailed them out. And just part of that might be because the shut-in language is prorated in the lease that we offer.
Other questions?
Can you describe again the how you determine when a well is actually shut in? Is it based on a 30 consecutive days, a calendar month? How that determines when you deem a well to be shut in?
It would be zero production for the entire calendar month.
Okay, so you could start out 1 month with no production, then you'd go through the whole next month before you deem it to be shut in and have to make these payments, correct?
Okay.
Did you hear that question?
No, I missed that. I'm sorry.
So so that the 15th of the month, the well stopped producing, and then you wouldn't consider it shut in until it went through the whole next month, so for about 45 days before it would actually be determined as a shut-in well in your all's view.
That's how I think it.
Okay. Now, has that situation occurred in this particular unit? Have you had months where the well has actually been shut in to this point?
No, sir.
No?
That's perfect.
How about in the other operations that you have? Do you have months where you have shut-ins?
At Deep Mine 41, our number 5 site is currently shut in on non-production and low methane. It has been shut in for some period of months. However, Intervest owns 100% of the mineral interest in that GOP area. And given that their lease dominates, and that there are other producing wells inside of their acreage, no shut-in payment has been tendered yet. And we would not anticipate tendering Intervest a shut-in payment until and unless all the wells inside of their 41 leasehold are shut in.
Okay. Another thing you mentioned in your testimony there was that your revenue stream is based on an annual production number versus a monthly production, which is typically the way things are handled in the coal bed methane or in the natural gas production within Virginia. Would it be reasonable for you to revise your order that would state that so that someone who's being deemed leased would have an understanding that they would only be getting a compensation once a year as opposed to monthly, which is how people are typically compensated now under other pooling orders?
In terms of shut-in payments or royalty payments,
Just in regular royalty payments,
that would be fine.
so that people would know, they'd have a better understanding of that. And then I think the shut-in is somewhat clear, but it's still a little bit clear on how you determine what the shut-in is. You may want to modify that to say that it's 30 consecutive days within a month before that. And that would be, you would make that payment within, what, 90 days of it being shut in, or 30 days of it being shut in? How does that payment get made?
Going from memory, I think it's 45 days. After
Is that
the,
in? I don't think that's in the order, though. Is that correct? Or is that just in your lease agreement with Intervest?
I believe that's just in the lease agreement with Intervest.
So maybe the order should also reflect a time frame for making that payment also.
Yes, sir.
One other question. I think we got an affidavit of your due diligence on this operation. Let's see if I can read this here. There's a statement in here that said there are owners and claimants, and there are owners who are unleased and or who are not previously pooled by prior orders of the Virginia Gas and Oil Board regarding Key Rock M26-1. Does that mean we've got new people involved that weren't in the original order now? That there are new unleased people that we're now going to be deeming to be leased, or is it the same ownership? Is ownership changed?
It's the same ownership.
So that statement is not true that's in the affidavit then? Is that misleading?
I'll be honest with you, Mr. Jansen, this has been I didn't know what to file for a modification, as far as, the affidavits. I was going off the ones that we had previously filed. The only time that they would ever have been pooled, I was going back as if it were the original pooling order.
Okay.
So if there's an error there, that's my fault.
Yeah, it just seems like that's a little confusing. It sounds like we've got new people involved in this modification to the order, but it doesn't, sounds like it's all the same people.
It is
That's
all the
correct.
same people. Yes, sir.
Okay, I just want to make that clarification there. That affidavit may need to be revised to reflect that we're still talking about the same people, that there aren't any, because if we had new people, you would have to do a modification to your order. If you came up with a new owner, you'd still be required to come forward and pool those people also and give them election options.
Well, I need to file a revision to the affidavit anyway, because, and this is what I thought you were going to ask about. The majority of those shows that they are in transit. Unfortunately, my office has been closed down for the last week and a half due to injury and illness of my staff, and I'll need to file an updated affidavit anyway. That will show the delivery of those certified mailings, and I can make the change that you're talking about.
Yeah, that was going to be one of my other questions about, I wasn't sure what that in transit meant, because I was wondering if those people had not received their notice, should we postpone this hearing until the next month? If they haven't actually.
They've been sent, but it's been a heck of a January for my office so far, so. I had
But I
one lady
understand-
fall in the parking lot and break the wrist, and the others had COVID, so.
Right. So there probably are parties who have not actually received their notice, other than we would be relying on them to have received their notice through publication in the paper. If that's acceptable to the board.
I can't give you, I can give an updated affidavit, before the close of business. I can't tell you right now how many of those have been received, but I would expect Most, if not all of those have been received. They should have been.
Okay.
Other questions?
Mr. Harris, I do have two additional questions, that came up, while questioning Mr. Pate, if I could.
Yes.
Just so that the board gets an idea of the proportionality of what these particular owners, would receive, is the shut-in, payment, if they were to receive that, on a monthly basis, more than they would expect to receive from loyalty?
Yes.
Is it far in excess?
Oh, yes.
Okay.
Or on a monthly basis, yes.
On a monthly basis. And what you are asking is that the shut-in payments align with the same percentages that you pay royalty.
Correct.
Okay, I just want to make
That
sure.
means that refers back to her question. They will get less.
But it will be based on their ownership percentage.
But our ownership, not our ownership, our royalty payments, I've already tried to calculate this out in the book for these 20% mineral owners range somewhere between $5 and a few hundred for the largest mineral owner. So across the board, a 1,000 a month shut-in payment for these 20% owners would far exceed, the total annual royalty on the profit.
They're still making more money than what we give to them.
Oh, yes.
But just not the $1,000 a month.
Correct. At $1,000 a month times 25, mineral owner interest, that would exceed the cost of plugging within 2 months of the total bill. And it would eat away all of our profits within a single year. To the point that if we had a shut-in, period, we would be forced to plug the well immediately. We could handle, and this is one of the lighter ones. If we were to look at the honey camp, that has 52 or 55 involved, that would be a 55,000 payment a month.
Yeah. Now, does that have the same shut-in? So I'll just speak what I'm thinking. If this is approved going forward, then we're going to see other petitions to make that change as well. Is that?
That is correct. This is mostly specific to D-minus 26. When we look at D-minus 41, half of those silver berries are 100% owned by Intervest, and the ones that aren't have only a couple, I think 5 is the most, other offset mineral owners in the pool. So this is mostly the D-minus 26 problem. But yes, I think that we would bring, all of the orders back in front of the fixes.
Any other discussions? I mean, I'm not, well, I shouldn't give my personal feeling, but it's almost like, this probably isn't good for the record, but it's almost like you dug a hole and fell in it, and now you want us to dig you out.
Partially.
Yeah, I'll make one other comment there, Mr. Harris. And
Yes.
you can correct me if I'm wrong, Mr. Pate. I believe that this board has approved some recent applications by Key Rock that do utilize the pro rata methodology on shut-in payments as opposed to the $1,000 per person. Is that correct?
Correct.
So we wouldn't have to you wouldn't correct all the applications, just be the early ones.
Just the early ones. Like I said, all of our early, items that we brought in front of the board were for D-minus 41. And this really wasn't, a large issue at D-minus 41. And so the language just carried over into 26. And once we actually paid attention to the royalties and the shut-in clauses, and especially once we started sending out leases, That's when it became fairly obvious that this was wrong.
Well, my other concern is the notices. Because we really don't have in front of us a certification that those notifications have been received. And I'm not sure we should proceed forward until we get some kind of certification that those have gone. I mean, you can't do anything about the newspaper. You just assume people are reading it. But the return receipt ones that become part of the file, I would think we would need those. Other board members want to speak to that? You know, right. So,
Yeah, I'd be willing to make the motion that we continue it for next month to allow confirmation of the notices and to allow QROC to make the changes to the application that I'd asked for. Then we could review those again. They could get with staff to make sure they cover all the terms correctly for the shut-in and in more clarification with the how their procedure for paying their royalties would go forward to.
so would that be a motion? I mean, we can vote, and if it doesn't pass, then we'll take other action.
Yeah, I'll make that as a motion if someone wants to second it.
Okay, we have a second. Any further discussion before we vote? So the motion is to bump this to next, that's not official language, but continue this to the next month, and then hopefully we have the other information that we need to make a decision.
And just so, Mr. Hatch, just so that, I'm clear, I will have you an updated affidavit, shortly. I've actually asked, my lady, at the office, she's going to update those. I'll try to have those uploaded today, with the corrected language, that Mr. Jansen wants. And the other items that, Mr. Jansen mentioned, just so that I'm clear, there would be a time frame for payment, and then a more clear definition of the 30 days, when it would be 30 consecutive days. Is that correct?
Correct.
Okay.
And then the language concerning how your royalty payments are only made on an annual basis as opposed to a monthly basis. Some language there that clarifies that in the order.
We do have a motion on the floor, and it's been seconded, so I guess we're ready to take a vote. You call the board, please.
Yes. Mr. Cochran,
Yes.
Mrs. Gibson,
Yes.
Mr. Harris,
Yes.
Mr. Owens,
Yes.
Mr. Prather,
Yes.
Mr. Jansen,
Yes.
and Mr. Ratliff.
I'll abstain.
Will be continued to the next month.
That's right, Mr. Harris.
Well, if you need some other information, I'm sure that the division can get the list of items that were mentioned.
I just want to make sure I get everything in the post order so I can get you another draft. Thank you.
Thank you. Thank you. We'll move on to the next petition. It's from Pocahontas Gas LLC for the disbursement of escrow funds heretofore deposited with the board's escrow agent attributable to tracks 1B, 1C, and 5B as depicted, upon the annex table. 2, authorization to begin paying royalties directly to McGuire Perk Heirs Trust, James Cantrell, Kathleen Arrington, and Perry Black. Unit V 37, I have trouble reading this. W37 thing. Docket number is BGOV 98-0324-05 32-07. We'd ask everyone who wishes to speak to this, to please come forward.
Mark Swartz and Kelly Berry. Good morning.
Morning. You may proceed.
Sarah, could you swear Kelly in for us, please?
Mrs. Berry, do you swear and affirm that your testimony is the truth, the whole truth, and nothing but the truth?
I do.
Kelly, could you state your full name for us, please?
Kelly Berry,
Who do you work for?
Pocahontas Gas LLC.
Did you prepare this petition and the related exhibits?
Yes, I did.
And what did you do to notify the interested parties that we were going to have a hearing?
I mailed a copy of the petition to each payee by certified mail with return receipt requested.
And have you filed those certifications with the board?
Yes,
Okay. And what we're looking for today, this is, first of all, a request for disbursement from escrow, correct?
yes,
And in the event that it's approved and we're allowed to pay directly to the folks that are identified here, we're also asking for authorization to pay those people directly in the future rather than escrowing their royalties.
that's correct.
And then we have a reference to a dismissal of coal owners. And here we've got sort of a hybrid situation that we see with some frequency, to some extent because of the split agreements. Hurt McGuire is going to receive funds, correct?
Yes,
But to the extent they were unable to enter into split agreements with all of the gas claimants, Hurt McGuire has previously been dismissed, or their claims in that regard have previously been dismissed.
that's correct.
Okay. Let's go forward here. The basis for in the application, you really have two reasons or explanations for the request for disbursement. One is a royalty split agreement, correct?
Yes,
And the other is we have gas claimants under 45.2 1624A who are entitled to 100% payments, correct?
yes,
Okay, and then we go to table. You have two tables here. Get this a little larger so I can see it. Okay, you have table one, correct?
yes.
And why do we have two tables in this instance instead of the normal one?
Track 1C has prior owners that need to be paid from escrow up to the date of their conveyance.
Okay, and does table one that then accomplish that payment to the prior owners?
Yes,
And what's the timing of the payments here that the escrow agent should pay attention to?
they will pay these exact dollar amounts based on the escrow account balance as of September 30th, 2007.
And who should they pay and what amounts under table one?
Both payments are being made to Jamie Cantrell for a 1/32 interest, which equals out to $49.52 for each interest.
Okay, and once those payments have been made, then the escrow agent should attend to table two, correct?
Yes, for tract 1C.
And table two is not a dollar amount distribution, it's a percentage, correct?
Yes,
So having made those two payments in table one, the escrow agent should then use the percentages set forth in, I guess it's the third column from the right-hand side,
yes,
to calculate the percentages due or the payments due to the people identified in table two. And obviously we've got some extra folks here that we didn't see on table one.
yes,
And I think you have identified the wells that have contributed to the escrow account on this exhibit, table two.
yes.
Okay. Then the next page, which I guess is PDF page 8 is Exhibit E, right?
Yes,
And those are still people, and that identifies people who are still going to have interest or claims against the remaining escrow balance.
that's correct.
Okay. And then the next exhibit is double E, and that would be, in the event this application is approved, that would be the way you would be paying going forward.
Yes,
And if we go to PDF page 12, that's Exhibit J, correct?
yes, it is.
And what does that accomplish?
To reconcile the bank's accounting of deposits with the company's internal accounting of deposits into the escrow account.
Okay. And I notice you've got, if we just stay with the first page, you have some entries highlighted in yellow, and then you have some entries where you have them outlined in a heavier black box as well, correct?
That's correct.
What do the yellow entries indicate?
The yellow entries indicate deposit amounts that could not be reconciled between our deposit information and the banks. And then the solid, heavier black line outline indicates deposits that don't match on the face line for line, but when you add them together, they equal the same amounts.
Okay. So we've got on page 1, for example, we've got some deposit discrepancies compared to checks that were written that we can't resolve and some that we've been able to.
Yes,
As we go through Exhibit J, we've got a few more of the same yellow highlights and darker black outlines until we get to, I think, PDF page 16, and then it looks like after that there are no question marks, so to speak.
yes,
And then at PDF page 17, we have kind of a recap, right?
yes.
And that, tell us what you did there.
This totals all of the amounts that have been deposited, taking into account distributions that have been made, and reflects the company grand total and also the First Bank and Trust balance as of October 2024.
Okay, and there's obviously a difference.
Yes, the First Bank and Trust balance is $505.82 less than the balance that Pocahontas Gas shows.
Okay. And maybe to remind, I think we've got some newer, not brand new, but newer board members. Have several banks over time been responsible for these escrow accounts?
Yes, quite a few.
And early on, why don't you tell us about, the quality of the banking over time, or at least the records that we.
The tracking of the records as far as deposits is concerned has vastly improved over time. Back in the 90s when this particular escrow account began, you had paper copies of accounting being exchanged between the bank and the companies, and it just was not as accurate.
Have you had access to the paper records to?
Yes, we do.
Try it, okay. So in some instances, there just isn't any record that explains it. Is that correct?
Yes, that's correct.
Okay. Let me see if there's anything else. And then the balance of the records here are just confirmation that we to the extent that Kurt McGuire did not have split agreements, we previously provided them with a notice that they needed to make a claim, and obviously they haven't.
Yes, that's correct.
Okay. I think that's all I have, Mr. Chairman.
Any questions from the board? Okay.
Miss Bailey,
Yes.
Sorry. Miss Berry, did you say this would close this account or will there still be a need for the escrow going forward?
There is one tract remaining in the escrow account, and it has been previously shown as a title conflict, and we're currently reviewing that conflict to see if it can be resolved.
Thank you.
Anything else?
No, that's it.
Mr. Schwartz, there's a supplemental affidavit of mailing. You just address that quickly. I guess that is what we needed for our records. That's page 18.
I'm not sure I understand the
No,
question.
okay. No, well, that was added after everything. I guess that's part of the record of return receipts and agreements. And okay, that's just scratch the question.
Okay.
Any further questions? I'll entertain a motion concerning this item.
Motion to approve.
Okay, I have two of those, but whichever you want.
I'll second.
Okay.
Okay, so we have motion and second. Any further discussions?
Miss,
Yes, could you?
Mr. Cochran,
Yes.
Mrs. Gibson,
Yes.
Mr. Harris,
Yes.
Mr. Owens,
Yes.
Mr. Prather,
Yes.
Mr. Jansen,
Yes.
and Mr. Ratliff.
Yes.
Yes. And so we will move on to the next item. And it is a petition from Pocahontas. I'm wrong. Looking at December. Okay, a petition from Pocahontas Gas LLC for pooling under the Oakwood COVID methane gas field 2. Unit is Y34. Docket number is VGOB 24-1217-4298. That was continued from December of 2024. So we'd ask all parties who wish to speak to this, please come forward.
Mark Schwartz and Kelly Berry. Mr. Chairman, Kelly and I have reviewed this again in preparation for the hearing today. And we have concluded that we need to modify our application to reframe it a bit rather than try and provide ad hoc additions. And we would respectfully request that you continue this to the next hearing so that we can modify the application and get that squared away before we offer our evidence.
Okay, that will be continued.
Thank you.
Okay, yes, you're welcome. Anything else?
Not from us.
Okay, thank you, Ben. The board will receive an update on board and division activities from the staff.
Well, it's been a pretty busy month, been processing a lot of coal dismissal disbursement petitions and treasurer disbursement petitions. So there's a lot of that been going, quite a bit of activity.
Yeah.
And it looks like right now we had 2 items already on the docket for next month coming up. So we've got 2 continuing. So we at least know there's 4 time being for next month.
Now, good. Okay, thank you. The board will review the December 2024 minutes for approval. If you had a chance, you do need a motion.
Mr. Chairman, this is Donnie Ratliff. I'll make a motion to approve to accept the minutes as presented.
Okay. Do we have a second? Second. Thank you. All in favor, say yes.
Yes.
Yes. Opposed, no. If you refuse to accept minutes. I'm sorry, that shouldn't have been on the record. I was just curious. Every board that I've been on, only approved them. I think, when haven't you done? Okay, I think we are done. Unless there's something else that, folks want to entertain a discussion on unrelated to what we're doing. Okay, folks, I think we're done. Thanks for your participation, and the meeting is adjourned.